Good afternoon. Welcome to the parallel session, which is dedicated to the topic of ensuring early access to criminal legal aid for suspects and accused. Already for a day and a half at this event, we've been talking about not just legal aid, but we have been talking about effective legal aid. Effectiveness is a kind of a big word and means many things to many people. When it comes to legal aid, one can be looking at effectiveness from defendants and suspects' perspective. So what is effectiveness of legal aid when if I am arrested or detained? What is effectiveness of legal aid from the perspective of a judge who handles the case? And what is an effectiveness of legal aid from the legal aid authority, from the Ministry of Justice, or a public institution which is in charge of the public funds to pay for legal aid? So they obviously want to take the responsibility for the public fund they spend, so they want to make sure and ensure that legal aid is effective. Probably, I guess, police and investigations, they have their own opinions of what effective legal aid is, but maybe not to go there, although we will touch upon this matter. I personally really came to realize in the work I was engaged in early 2000, starting from Lithuania, I described yesterday, but also in other countries, that actually they're getting lawyers to represent people, that they do their best job is just not enough. It really made a huge difference at which point they were entering the trial. And as a practice, we were discovering that, that by the time they would come to the police station and would meet with their client, much had been resolved already. The people had been questioned, statements taken, the statements signed, so that there was quite often quite little that lawyers could do to really change the circumstances. So we really thought that really ensuring that there is that the right to a lawyer is enjoyed. And the right to legal aid is made effective or accessible from the moment the person is arrested or detained, or otherwise the person's situation is undermined, may really hold answers to many aspects of effectiveness legal aid, and not only from the perspective of defendant, but also from the perspective of criminal justice system, not only from the perspective of making the process fair, not only the outcome, but also from the perspectives of ensuring that there is accountable and an effective and efficient management of the criminal justice system. There are many other arguments that why early access is crucial for ensuring access to legal aid and effective administration of criminal justice. All of those, hopefully, we will touch upon during the panel discussion today. It's a great pleasure to introduce the panel of 5 remarkable practitioners and experts in the field. I will start with the order of presentations. Professor Ed Cape from the United Kingdom, who is the author or key, kind of the drafter of the handbook which was produced by UNDC and UNDP just recently on the matter, and which has been included in your kind of handout materials. He's the person who was probably at the very beginning, at the foundation of establishment of the oldest early access model in the world. That was the England and Wales as a jurisdiction in mid-80s. Libby McWade, who represents Fair Trial International, the human rights organization which promotes justice and fair trial in the UK and in Europe and globally. Libby is going to really address and talk about the recent developments that have really shaped the criminal justice policies and procedural safeguards work of the European Union, and the process of really advancing their implementation. Dr. Anna Horowitz, who is the Deputy Public Defender of Israel, who is going to reflect on the experiences, some recent, but already quite some experiences of introducing early access or 24-hour duty lawyer model as part of the Israel's public defender system. Isadora Fingerman, who is representing an organization, Institute for Defense of Brazil. It's a longer title, I guess, but just shortened it a little bit. And she's going to really describe the results of the pilot they initiated in São Paulo to really test the cost-effectiveness of the approach of providing early access to people who are incarcerated and kept in custody in São Paulo. And unfortunately, our speaker from Sierra Leone, Simon Koroma, could not make it to the event due to visa-related complications. His visa did not arrive in time, despite all the efforts he put in this. But we have a really excellent replacement, the Clifford sister, who was really willing at a very short notice, just a few hours ago, to really step in. Obviously, he's extremely well qualified to address the matter of early access. Experiences in Malawi, because Malawi is kind of also considered, and his project, he personally, the birthplace in Africa, and probably beyond, of the role of paralegals in addressing over incarceration and prison. The overcrowding of remand prisoners, especially in Malawi. The model which has been copied not only on the continent, but in many other countries outside of the African continent as well. Our speakers will make very short presentations, and then we'll have a small question-answer session at the panel, after which we'll really have the open discussion with the audience. So, Ed, why don't you start? And